that took some time, and we got ceiling tiles. So what to expect today? What to expect today? Well, I can take that banner down there. Well, it's closing statements today. Opening statements on 3 days ago. The state needed around 15 minutes, and the defense needed around 5 minutes. So I would expect a little bit longer because, in my opinion, the state's case, even though the facts are there, but the facts need to be substantiated, and in my personal opinion, not as solid as I expected. Frankly, it was far from as solid as I expected. We can start with, well, let's start with the sister. Showed up unannounced on the crime scene. We have seen that before. Smiling and giggling. Now you can say that, oh, shock. Yeah, but shock wears off. People react differently. Of course they do. But her reasoning was that she was a friend's uncle or something passed away. So it was a weird excuse they used. And her demeanor, so that was very, very weird and strange. And just the fact that the prosecution did not want that in, try to have it out, because they know it looks bad. With the only other, more or less the only other person that could be remotely a suspect in this case. And again, that daughter, Kylie or something, so as far as I know, the only person in that family with a history of violence towards her mother. Let's check motive. Well, maybe she just didn't like her mother. But that wad of stash was troubling. That she just flinged up on the interview table. Because they were planning, her mother was planning a trip. And had taken out money for that trip. Was that accounted for? The amount of money? No, it was never entered into evidence that the money she had taken out was the money that was retrieved on the crime scene. Hi, Christine. Hi, Sky Bell. Hi, Sir Frank Otter. Tim Westland. Marita Finn. Swan Lake Lady. Siobhan. Snivels. Fun Size, Dave was here earlier, and Phoenix. Good morning, y'all. Member for 6 months. Thank you so much. Thank you for the support of this channel. I see Will Call Magic as well as Janice Baldwin, Denise Sells. Let's see. Yeah, I think I went through the people who the Sock Snatcher and Monmouth Tennis here and Wim Daddy Talk. The jury is coming in at 10:45, Christine says. Okay. I haven't seen the information about that yet. Let me check other places. 10:45. Well, that's 10 minutes from now. 10 minutes from now. Don't forget your pants. I will never forget my pants. They are over there. Thank you, Dolly. Thank you so much. Gifted 5 memberships to Louis Thomas, Tim Westland, Swan Lake Lady, Pants. Oh, don't forget your pants. It was Pants who said, don't forget your pants. I missed that. Pants was gifted a membership, and Camille Gordon. You now have access to all my members-only content and your own emojis. And I keep forgetting to put the link to the Discord. Let me just do that. It will be a members only in the community section. There, let's see here. Dun, 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 dun. I'll do that right now. Community tab. Visibility, all channel members. Yeah. If you have a different name on Discord than you have on YouTube's, then please tell the mods what's that, so they can listen. Okay, where were we? Yeah, the sister. The only thing they checked was they checked one traffic camera that stared down the road, but they didn't see her front door or her back door from that. So, well, her phone was home. So what? Then we have the alleged murder weapon. Absolutely zero evidence, in my opinion, that hatchet is the actual murder weapon. Now, the prosecution claimed that he washed it off. Okay, with what? Water alone isn't enough. Barely soap and water. No, you need alcohol or bleach. And they didn't test for residue. No residue. They found his palm print on it. Yeah, it's his. I would be more surprised if it wasn't. And that palm print had smear, as if somebody had grabbed it afterward. It could be himself. We don't know. Do we know if they checked for the sisters? I don't think so. I don't think they checked anything with the sister, if her prints was anywhere, but they claimed everything else was just smudges. The only thing they could retrieve was that palm print, which is strange. But stuff happened. So yeah, and then they took time to describe the defendant as very, very strange. That he peed himself. Okay. He had an erection. Okay. None of that shows guilt. For me, that is the prejudicial outweighs the probative value of that information. It only shows that, okay, he's strange, he's weird. He probably some kind of mental illness in the background. And then they tested him for different drugs. And the only thing they found was cannabis in the system, as in gummies or edibles or something was the indication. And the prosecution, in their questioning, well, can you rule out just because it didn't meet the threshold? It was such an overreach, in my opinion. That question, was that really necessary for the jury to take a stand on? or it could have, but could have. If you ask, if the answer or the question is somewhere in the line of could have, would have, maybe, that's reasonable doubt in itself. I believe that the prosecution rushed this unnecessarily. Now, speedy trial apparently was in action, but still, between January of this year and mid-July of this year, it's a lot of months to conduct a proper investigation. Did they check the daughter's social media? If they put up photographs when you can show an injury? There's a little movement now in the courtroom, I can see. Yeah, all men who are capable to have an erection are weird. Yeah, especially, I mean, morning wood is not that uncommon. Yeah, I agree, Scriber. The sister behaved so strange. Very, very strange. Now, the information from, and also information from the last witness from the state was that apparently this Taylor gave the information that he showered just before they showed up. Yeah, but what he says and what he did might be not truthful. We don't know. Then you have the placement of that hatchet. Why there? I mean, that would be an extremely strange place for that hatchet. Speculatively, conspiracy, whatever's. It was very placed. And then you have the coroner didn't conclude a time of death. Now that is of minor importance in this case. But for me, there's not enough evidence, for me at least, to go beyond reasonable doubt. Yes, all the facts are there. He was in the house. He owned a hatchet. He called his mother really, really bad things. And this witchcraft thing. Could he have snapped? Sure. But even the mother's best friend, the victim's best friend, said Taylor was not a violent person at all. And then she added, unless you pushed his last button. But nothing shown in this trial shows that he was pushed on his last button. That's strange and weird in this case, and I don't like it. I really, really don't like it. Because this was supposed to be a clear and cut case. Louis Thomas, are his interview videos out? I don't think so. Let me check. Dun, dun, dun. No. Let's see here. Can find it elsewhere. No. Nope. Hi, Dave. You had to disappear for a minute. We are waiting for this trial stream to move on because I needed to move on because 11:30, the YSL, Young Thug, the hearing with the new judge or the meeting with the new judge starts. So I kind of need this to move along. But my priorities today is get this, move into verdict watch. Then I will stream the hearing today or the meeting today between the new judge and the attorneys and the prosecutors in the Young Thug case. And have the verdict watch over there while we watch that. And if we don't have a verdict when that stream is over, then we will see if there will be a verdict today at all. I would assume. Maria, didn't the YSL judge recuse herself? Yes, she did. And then they appointed a new one, Judge Whitaker. And she is holding a meeting or a hearing today with the attorneys. So new judge number 2 is placed. And it seems like she's not recusing herself. And from what I've heard, she is a very fair and efficient judge. That is her, and she has been on the short list for the Georgia Supreme Court. So this is a person who likes the law. Yeah, so, but if there is no verdict in this, I expect a verdict to be quite fast in this because it was a 2-day trial. Third day is closing statements or closing arguments, and then it's verdict watch. And I assume they will be unanimous no matter which way. That is my assumption. So, and if it isn't done at the end of my Young Thug stream, then I will put up a stream as soon as I hear from the court that they're on. But if that it doesn't happen, I have the panel show at 6 p.m. Eastern Time today. I have had answers from Doug Weinstein that he might show up. Then I have invited Katnott Williams, Kayla Bumpus, and infamous Sylvia, and AV to the 7th power. And I haven't had answers there yet, but it's early in the morning. I didn't expect any answers until later today. But if I could probably invite Dave as well, even though Dave, he's been watching the trial and he's been around in the background, so he can give us input. Maybe MG Law. Yeah, a good panel at 6 p.m. A Friday panel show. I've had those Friday panel shows now a few Fridays, and I like the format. And I hope that could be a reoccurring event. Maybe not every Friday will be about the Young Thug trial, but just what happened during the week, because we have a bunch of trial streamers who cover other cases. I might have Baker on about Baker and others about the what's that case now again? The Karen Reed case, or Megan and Umbrella Guy about the Laura Owens case, or whatever is going on. I hope. Dave is retired. He claims. Friday this evening would be a great time to jump on. Yeah, great. Okay, I will send you an invite for this evening. this movement in front of the camera. We are currently watching a bald spot and ceiling tiles. Oh, now they're going to get real movement. Now, what else about this trial? Well, the defense put up one witness because they tried to allege that there were tracks behind the house. That was a bad call. Because that witness said, it's animal tracks. All right. Yeah. They had. If it was my case, I would have tried to at least have on a DNA expert to try to destroy the state's DNA evidence. That would have been my choice, but you can't get everything you want. Oh, hello, LV Cowboy. Her response was way too questionable for me compared to a stoned guy just waking up. Yeah. The fact they didn't even look into her is the big problem because there's no evidence left at this point. Yeah. Hi, Diogo. Hello, Diogo. Who else is here? Well, say hello to Mr. Jingles. Hello, Mr. Jingles. Hello. Want to say hello to the people? Hello. You go over there. Yeah, you go over there. What else about? I didn't like the evasiveness from the state's DNA expert. Now, compared to other trials, she did excellent testimony about not only the DNA and the blood evidence, but also the lack of DNA and blood evidence. Just the fact they didn't distinguish, they didn't test if it was animal blood or human blood, because as you might know, both the mother and the dog. Hi, Skybell. You got 3 cats. Yay. I only need 1. Well, I can only have 1 because Jingles, if a cat tries to get into his territory, there's a fight. No, for some odd reason, Mr. Jingles is never amused with me picking him up and showing him to the rest of you. Yeah, the DNA expert. I mean, I know there are budget restraints on testing for DNA and blood and stuff, but that shouldn't be. And that shouldn't be. How do I explain this? That shouldn't be held against the defendant. That the state doesn't fund their DNA lab or their testing lab enough. They should, because if you're a juror, you shouldn't reward the state for putting forward bad evidence. Or, well, why didn't they test the shower curtain, for example? That would have been an excellent piece of evidence if he showered off a lot of blood and everything, but they didn't test it. That, in my opinion, should work against the prosecution. How old is Mr. Jingles? He is between 8 and 9. Hello, Shield Maiden. He's between 8 and 9 years old. A friend of mine found Mr. Jingles and Buster, his brother, in an abandoned barn about 8 years ago. They are not sure how old they were at the time because they were tiny. So they could have been from a few months old to up to a year. Meme raid. Yay! Hello, folks from Meme. Here we go. It is closing arguments in the Iowa v. Tyler Dazey. Right. Jury's on the way in, I heard. Hi, Dave.
Hello, hello. I'm just on my laptop, so hopefully the sound and picture's okay.
Yeah. Everybody, how is sound in your end? Please tell me if there are some discrepancy.
So, okay, so I didn't realize they had closing arguments yesterday.
Please be seated, everyone.
No, they have it today.
I didn't realize they finished their case in chief, I should say.
No, I was surprised yesterday as well. And extremely short.
Good morning, folks. When you came in the courtroom this morning, the court attendant handed each of you a set of jury instructions. I'm going to read aloud to you this morning the first about 80% of those. Then we'll stop. We'll do closing arguments from the attorneys.
Sounds so inviting.
And we'll come back and read the last few.
Read you
80%. That way
I like this, Josh. He's very efficient. I don't agree with two of his rulings in this trial, but he's extremely efficient.
The court is a little low. I don't know if you can boost it.
The first part is more the meat or the substance of the law. So I'm required to read these to you out loud. You can follow along with your set if you'd like, or you can just listen, whatever works best for you. Instruction number 1, members of the jury, the trial information charges the defendant, Tyler Dazey, with the crimes of murder in the first degree and animal abuse. The charge of murder in the first degree includes the lesser crimes of murder in the second degree, voluntary manslaughter, and involuntary manslaughter. Instruction number 2, Tyler Dazey has entered a plea of not guilty. The plea of not guilty is a complete denial of the charge and places the burden on the state to prove guilt beyond a reasonable doubt.
That's an excellent.
Whenever I instruct you, the state must prove something. It must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Instruction number 3, the trial information is the document that formally charges the defendant with a crime and is merely the method by which the defendant is brought into court for trial. It is not evidence. The defendant has been charged with 2 counts. You must determine whether the defendant is guilty or not guilty separately on each count. Instruction number 4, Tyler Dazey.
That's the instruction the Karen Reed jury should have had. Because that was extremely confusing the way she did her jurisdiction. I like this judge. It's a no BS kind of judge. But he did allow speaking objections.
I'm okay with speaking objections generally. I don't like it when the judge allows it argument to take place in front of the jury.
Yeah.
He is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable.
Yeah.
Was he there at all for any of the trial?
Nope. He put the letter forward, I do not want to be there because something about the Arabic family's royalty, semicolon, I, Tyler, colon, sausage stuff mixed with Abraham.
See, that's interesting because this is the second trial that I've seen on the YouTubes where the defendant, I think this is the second one that you've streamed, where the defendant isn't there. Maybe Baker streamed the other one.
No, but that was Baker.
I have never heard of it before. And I'm wondering how that impacts the jury.
Yeah, I'm not sure. I wouldn't like it. I want to see the defendant react to what's going on.
Yeah, definitely. And hey, everybody in chat, see you all.
Out. Instruction number 5, you shall base your verdict only upon the evidence and these instructions. Evidence is 1, testimony in person or by deposition. 2, exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. 3, stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to which were not offered and received into evidence are not available to you. The following are not evidence. 1, statements, arguments, questions, and comments by the lawyers. 2, objections and rulings on objections. 3, any testimony I told you to disregard. 4, anything you saw or heard about this case outside the courtroom.
This is very efficient.
Instruction number 6, in considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Instruction number 7, decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence. But if you cannot, accept the evidence you find more believable.
He chose not to testify.
In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, 1, whether the testimony is reasonable and consistent with other evidence you believe. 2, whether a witness has made inconsistent statements. 3, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts. 4, the witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 8, you must determine whether the defendant is guilty or not guilty from the evidence and the law in these instructions. You must consider all of the instructions together. No one instruction includes all of the applicable law. Instruction number 9. Nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be.
That's an instruction your
Instruction number 10.
never make.
The burden is on the state to prove Tyler Dazey guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case or from the lack or failure of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense, and not the mere possibility of innocence. A reasonable doubt is the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt, therefore, must be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it. However, proof beyond a reasonable doubt does not mean proof beyond all possible doubt. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt and you should find the defendant guilty. But if, after a full and fair consideration of all the evidence in the case, or from the lack or failure of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt and you should find the defendant not guilty.
I like these jury instructions so far.
Instruction number 11, if there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt.
If you want to pause it, I can talk about jury
the
instructions
duty of the jury
real quick.
Yeah.
So generally, jury instructions are a collaboration between judges and attorneys, usually managed through the Bar Association. And then they will be recommended to the state Supreme Court as standard jury instructions, and then they get published. That's how it is in Michigan. That's how it is in most states. And they'll get published by the state Supreme Court as general or template jury instructions. And for the most part, those are what are used. However, they are modified slightly per case. And most courts and judges will say, all right, on this date or by the first day of trial, everyone should have exchanged their jury instruction, proposed jury instructions, I should say. And then the court will go through it with the attorneys and they'll finalize a final set with some modifications. Obviously, you don't use them all because this is a murder case. You're not going to use armed robbery instructions and things like that. And so that's how it's done. And so everyone has had a chance. They have a binder and we go through them all and we make the modifications. Do we need this one? Do we not need this one? Is this one going to be modified? Everyone's in agreement. And then the judge reads them to everyone. That's what happens.
Is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Instruction number 13, where two or more alternative theories are presented, or where two or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based.
Yeah, I don't like
instruction number 14.
No,
the law says no.
For me, the only thing that should be proven in a trial is the prosecution's theory of the crime, and that alone. If a juror, or say there are 12 of them, 4 believes, well, we heard all the evidence, but I think this, then it's not guilty.
Yeah, so that's one of the things. What they're talking about there is, if one juror thinks, well, I don't, I think he attacked her, but the cause of death was something else, or, but I still think he's guilty because he attacked her, or whatever. If the jurors don't have to agree on the facts, but still think he's guilty, I have a problem with that. The big thing came up with the Crumleys too. With were they grossly negligent because they left the gun out, or were they grossly negligent because they didn't get their son help? We don't know. We don't care. If you just think they were grossly negligent in some way, you can find them guilty. And it's like, but you should be able to unanimously agree on the facts, right? That's what we think of.
Or in this case, well, they didn't prove that the hatchet was the murder weapon, but I still believe he killed her. When that's not in evidence, you shouldn't be able to come to that conclusion. So,
To commit a crime, a person must intend and knows the act is against the law. It is necessary that the person was aware he was doing the act and he did it voluntarily, not by mistake or accident. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 15. The state must prove all of the following elements of murder in the first degree. 1. On or about the 18th day of January 2024, the defendant struck Jennifer Dazey with a dangerous weapon. 2. Jennifer Dazey died as a result of being struck with the dangerous weapon by the defendant. 3. The defendant acted with malice aforethought. 4. The defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Jennifer Dazey. If the state has proved all of the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree, and you will then consider the charge of murder in the second degree, explained in instruction number 21. Instruction number 16. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another, which exists before the act is committed. It does not have to exist for any particular length of time. Malice aforethought may be inferred from the use of a dangerous weapon. Instruction number 17. Willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Instruction number 18, deliberation and premeditation need not exist for any particular length of time before the act. Instruction number 19, if a person has the opportunity to deliberate and uses a dangerous weapon against another resulting in death, you may but are not required to infer that the weapon was used with malice, premeditation, and specific intent to kill. Instruction number 20, a dangerous weapon is any device or instrument designed primarily for use in inflicting death or injury, and when used in its
Now, this
designed
is
manner
overkill,
is
in my
capable
opinion.
of inflicting death. It is also any sort of instrument or device which is actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death.
Now we're into your instructions that definitely came from a prosecutor. I don't like these.
Well, these are probably general.
Yeah, but it's too much. I mean, to explain what a dangerous weapon is, either she in this case, she was killed with a hatchet, according to the prosecution's theory, or she wasn't. Why is it necessary to know that a dangerous weapon is a weapon that can cause injury? But well, yeah, sure. I'm not a fan.
Instruction number 21, the state must prove all of the following elements of murder in the second degree. 1, on or about the 18th day of January 2024, the defendant struck Jennifer Dazey with a dangerous weapon. 2, Jennifer Dazey died as a result of being struck with the dangerous weapon by the defendant. 3, the defendant acted with malice aforethought. If the state has proved all of the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you will then consider the charge of voluntary manslaughter explained in instruction number 23. Instruction number 22, murder in the second degree does not require a specific intent to kill another person. Instruction number 23, the state must prove all of the following elements of voluntary manslaughter. 1, on or about the 18th day of January 2024, the defendant struck Jennifer Dazey with a dangerous weapon. 2, Jennifer Dazey died as a result of being struck with the dangerous weapon by the defendant. 3, the act was done solely by reason of sudden, violent, and irresistible passion resulting from serious provocation. If the state has proved all of the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of voluntary manslaughter, and you will then consider the charge of involuntary manslaughter explained in instruction number 25. Instruction number 24, concerning element number 3.
What you say?
So apparently they have a lesser included. They're saying, well, if he didn't do it intentionally, he did it accidentally.
Yeah. Apparently in Iowa, when you have murder 1, the lesser included are there automatically, or something of the sort.
Okay.
Because he's only charged with murder 1 and animal cruelty, but there are lesser included in there. But he isn't charged with the lesser included. I didn't know that was possible. That's a bit of a cop-out.
Of instruction number 23, a serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring his or her passion under control and suppress the impulse to kill. Words alone, however abusive or insulting, cannot be serious provocation. Instruction number 25, the state must prove all of the following elements of involuntary manslaughter. 1, on or about the 18th day of January 2024, defendant recklessly struck Jennifer Dazey with a dangerous weapon. 2, the defendant struck Jennifer Dazey with a dangerous weapon in a manner likely to cause death. 3, by striking Jennifer Dazey and all the other evidence in the case. Instruction number 31, evidence has been offered to show that the defendant made statements at an earlier time and place. If you find any of the statements were made, then you may consider them as part of the evidence, just as if they had been made at this trial. Instruction number 32, in this case, the defendant has decided not to be present and not to testify. The defendant is neither required to be present nor...
Okay, now we are caught up again.
to testify. No inference of guilt may be drawn from these decisions. The burden of proof remains on the state to prove the guilt of the defendant beyond a reasonable doubt. Okay, that's where we're going to stop, and we'll pick up with instruction 33 after closing arguments. Consistent with how trial has proceeded, the state has always gone first. The state has the burden of proof. The state will go first with closing argument. When the state is finished, the defense will have their opportunity. When the defense is finished, the state has one last chance to come up and rebut anything that the defense said in their closing argument. So, Mr. Nelson, with that, whenever you are ready, go right ahead. Yes, please. Yes.
Yeah. They're actually using mosquitoes here. So the microphone are with them all the time. That hasn't stopped them from failing to talk into the microphone.
May it please the court, counsel, ladies and gentlemen. First of all, I'd like to thank you all for coming in here and giving us your time. I know there's a lot of things you probably be wanting to do on a nice week like this, great weather, but this is a very important function, and we do thank you for coming in and giving us that time. Secondly, I'd like to thank you all for paying attention. Sometimes things get a little boring in here, and I was watching, everybody was pretty much locked in as the evidence came in. So this is the time where all the evidence is in, and now we attorneys get a chance to talk to you about that evidence. What is the evidence? We'll start with Exhibit 1. This is about Jennifer Dazey and her dog Echo. Ms. Lassance introduced you to them at the beginning of this case. You heard about her health issues. She had brain tumors. She had a surgery to remove those. She was recovering, moving forward in life. That all changed as a result of a particularly brutal and heinous act on January 18th of this year, which ended their lives. This is the front of 1605 Avoca, where Jennifer Dazey resided. On January 18th, her friend Christy Folman came by for planned coffee. They wanted to get together. Ms. Folman had been dealing with her own health issues. In fact, both of them had been in the hospital at the same time for their various health issues. They were just kind of getting back in touch, getting back together. They planned a coffee to sit down.
For reference, if they are showing the victims, this will happen, because I refuse to show pictures of the victims on my stream.
And
didn't they not show them?
Catch up on things.
They did in this trial.
Ms. Folman arrived. She noticed right away that there was a truck in the driveway and Jennifer's car was gone. That's Jennifer's son's Nick's truck. She didn't think much of it because vehicles got traded periodically there, and it was no big deal. Next. She walked up to the house. She went into the porch. This would be the front door.
I'll be right back. I'm going to put my headphones in.
Yep.
Be coming in the front porch. She'd be right there, the front door of the porch leading into the house. She proceeded to open the door to go into the living room, and that would be what she saw. She opened the door. You can see into the dining room area. You can see the pillar in there that was talked about. It's pillars that separate the living room and the dining room. So she was looking right in through there when she saw Tyler Dazey between the pillars facing away, and he was naked. She stood up and said, this is what she saw standing there. She was surprised and somewhat embarrassed when she saw that, so she started backing out of the door again. Then she heard some footfalls and she heard a door close. She thought, all right, it's safe to enter the house. She goes on in like she always did. Next. She That's one too many. Oh, must have missed one.
Okay, how do I sound now?
Anyway, she
Do I sound better now? No echo? There shouldn't be an echo.
You sound like you're in a can.
Well, I wasn't prepared to stream today. I'm retired.
I do not know why the world of doom is. I have excellent internet, but I assume. Okay, let me.
I'm going to assume this a little better.
put her coffee down on the table. She took off her shoes, put on socks. That's when she saw the dog Echo on the couch under a blanket. She went over and picked up a leg of Echo and let it go, and it dropped. Now she began getting puzzled. She went to the kitchen. She looked and she saw that the door to the basement was closed, that she knew that Jennifer was not in the basement because anytime she went down there, she...
This is more or less the opening statement told again.
Well, in theory, it should be, right?
Yeah.
You should have no surprises during the trial. And your opening statement should be very close to your closing argument.
Yeah.
Except now they've heard all the evidence. It's very unusual. Actually, it's a sign that the trial went wrong if you have to change your closing arguments after giving the opening.
Mm.
left that door open. She tried calling and she tried texting. When she came out of the kitchen, this is back in here.
What's going on? Why the world of doom?
It only happens when I'm on. You know that, right?
Yeah, it's your fault. But I have had many people with me and have no issues since I got the fiber installed.
It only happens when I'm on. Seriously, I have no idea.
Yeah, I'm at
First,
over
what you get for
200.
bringing a retired YouTuber on your stream.
I am at 300 mbits down and 450 mbits up. I should have no issue. So this is a YouTube to StreamYard thing, and I assume it is because of the Microsoft fuck up last night.
Here, she looked over and saw right here a little nightstand sort of affair, which had Jennifer's purse on it. She knew that Jennifer never left the house without the purse. So now she was getting confused. She went to Jennifer's bedroom. The door was closed. That's an important point. So she went in the hallway, went down to Jennifer's bedroom. When she went in there, she called out softly. Blinds were drawn. It was dark. She was trying to wake Jennifer up. Hey, why are you still in bed? She could tell that Jennifer was in the bed, but she couldn't see any details. She moved closer, tried to wake Jennifer with a low voice. That's when she saw this. She closed the door, braced it with her feet, back to the door, feet on a dresser, called her boyfriend right away and said, I think Jennifer is...
Yeah, the videographer learned that just because the prosecution put something up on the screen, you shouldn't show what's on the screen, because they did that yesterday and showed both the dog and the victim. Yeah.
Well, that's what I thought they had said earlier, was that they weren't going to video that, and then apparently they did.
Yeah. Oh, for freak's sake. This is your fault.
I bet as soon as I jump off, it works.
Dead, get over here. Then she called 911 immediately. Got on the phone. Or you heard the 911 call. I mean, that was sheer terror. That's the only way to describe that. You heard Officer Hesselbecker was dispatched, and he arrived at the scene shortly thereafter. Ms. Fulman was on the 911 call, heard the officer enter the house, and she went to him and said, don't leave me. But the officer has a duty to do. He had to go investigate. So he said, go. And she went back into the kitchen, and she was hiding out back here near the pantry or mudroom or whatever they were calling it at the time. Officer Hesselbecker entered the room with his flashlight, turned on the light. That's the scene that he saw. You got to see that with the body cam that he was wearing. You saw the whole thing. You can look at it again if you want. You'll have that. We don't need to dwell on it here. You saw what he saw. He then called in and reported a homicide, and the cavalry started rolling. People started showing up. Lieutenant DeJuiced arrived, assisted in clearing the house room by room. He announced numerous times, police department, make yourself known. Numerous times. There was no response. They cleared the basement. They cleared the main floor. Eventually, they got to the room, back bedroom that Tyler Dazey was in. Officer Slide and DeJuiced cleared the room. You saw that on the body camera. They found Tyler Dazey face down naked. They thought it was a body at first. Then Officer DeJuiced said he's breathing. They decided that they wanted to secure him under these circumstances. Mr. Dazey complied with instructions and directions. He stated his right wrist hurt. There were no bloody clothes found anywhere in that room. Then,
or anywhere.
Mr. Dazey was ultimately placed in a tie
They
suit.
found no blood on his.
That was to.
They found no blood on his person, not under his nails, not on his hand. He had no injuries. They found no blood in the shower drain. Oh, they only swabbed around the shower drain because somehow they were unable to retrieve the actual shower drain. They only swabbed around that.
How long after, like, did they say like she died that day and they swabbed everything and got in touch with him that day, or is this weeks after?
No, he's reiterating what happened that day as now. Then crime scene investigators accessed the scene and started swabbing things. That is, if I remember correctly, the same afternoon and the day after.
Okay.
But they couldn't detach the shower drain, so they never swabbed in the actual shower drain to search for blood residue. And there were none in the bathroom.
Isn't Tyler at home? Why
Yeah.
wouldn't he be naked at home?
Yeah. And they also, when they did the blood and urine test, he was stoned out of his mind, but only with cannabis.
I hear that stuff is nasty.
Yeah.
Preserve evidence, and just to cover him, investigator Rosenthal noted at the time that Mr. Dazey had abrasions on the back of his right hand and the back of his fingers on his right hand. He was taken to Mercy Hospital to be cleared. He was followed in.
Yeah, that's by testimony only. They never photographed his hands. So that is by testimony only.
Really? They didn't take any pictures of his hands. They didn't investigate the sister.
Nope.
There's a lot that they didn't do. I'm seeing all kinds of reasonable doubt.
Yeah, this is tunnel vision. Let's do this the easy way, and it's him. Let's just the bare minimum and hope that nothing else shows up. Like her sister, unannounced, on the crime scene after they've been trying to call her for hours. She shows up, happy, smiling, giggling, joking. And in the car ride, she was put in the squad car, driven to the precinct for an interview. And in that car, she said she had a domestic case. She was fighting a domestic case against her mother because her mother accused her of slapping her. So the only person in that family with a history of some form of violence against the mother, is her. And she has no alibi. Her phone was home. Nope.
The defense didn't even call her? Well, I guess you wouldn't necessarily call her as the defense, but...
No, they never called her. They tried to have the interview, the prosecution tried to have the interview with her in a pre-trial motion eliminate. That didn't work. They never brought it up, anything about the sister in their direct examination of the interviewing cop. The defense brought that video up.
Instructions up there. Officers obtained search warrants for blood and urine to check for drugs and to look for possible influence of drugs. While they were waiting there, Mr. Dazey stated that he needed to urinate. He was asked to hold it briefly so a sample could be collected. Mr. Dazey stated, "I'm letting go now. The keys are yours," and urinated in the tie-back suit.
This is just character evidence, in my opinion, that he pissed himself several times in that suit.
I mean, it's bad character evidence for sure.
Yeah, yeah. I don't know what's probative about it to bring it up. But it is prejudicial. He's weird, he's strange, he pisses himself several times.
Did they do a 403, like prejudicial versus probative?
The defense did an objection by 401, 402, 403. I think they had a standing objections, but it was let in. That is one of the rulings I believe the judge did wrong. Because I don't see the probative value, evidentiary value, but it's highly prejudicial.
Yeah, I would agree.
When investigator Rosenthal told him that he could have held it a little longer, Mr. Dazey responded, "Wars are meant to be fought." He urinated in the suit several more times, and eventually at the law enforcement center, he said he needed to urinate again. Officer Rosenthal said, "You don't need to do it in the suit again." He grabbed a collection cup, held it in place to get a sample. Mr. Dazey then said it might take a while and that he didn't want to dick you around. Then he said, quantum entanglement, brother, urinated all over investigator Rosenthal's hand. Samples were collected in that incident. They were sent to the crime lab along with blood samples. The lab results showed that Mr. Dazey had ingested THC isomers of different types, which would be that contained in the gummies, the vapes, and probably from actual marijuana plants. These are these various modifications made to the THC. What they did not find was PCP, fentanyl, opiates, or any of the other hard drugs. So he was not under the influence of any of those things. Now, while all that was playing out at the hospital and the law enforcement center, investigators were working on the scene. Blood spots were found in the hallway outside Jennifer's bedroom, which would be in here. And they were also found in the dining room, living room area going over to where
none led to
the dog was
Tyler's bedroom.
On the sofa. A hatchet was found on a shelf in the bathroom, and there was a sheath to that was found on the dining room table. Both of those items are in evidence, and you can see that the sheath matches the hatchet. The hatchet also says SOG on one side, which is the same brand as the sheath.
Can I just say, you talk about like you can't buy hatchets or anything like that in Sweden. Well, you can, but you got to like take them straight home. I purchased a hatchet when I was in Wisconsin, and I had the thing out and just walking around with it. We were at a strip mall, and we went into like a couple other stores, and I'm just walking around with the hatchet. Nobody said anything.
No.
Thank God I live in America. That's all I want to say.
Camera was checked and showed several things. One, it showed the switching of the vehicles at around 8 p.m. the night before, where Jennifer's son Nicholas came, dropped off his truck, and took her car. Something wrong with his truck.
Oh yeah,
that would have been the evening of the 17th.
The daughter had access
Jennifer
to
let the dog out and in at about
ring
10
camera
p.m. that
footage,
night.
by the way.
Nothing happens on
yeah.
that ring camera until the following morning at 8:38 when Ms. Fulman arrived at the house. Officer Hesselbecker arrived at 8:51, and you saw all those video clips, people coming and going at the front door of that residence. Nobody else went in or out that front door. It was not on the camera. It's motion activated. There was nobody else in or out. Exhibit 24 shows the back door to the house with the deadbolt vertical. The testimony was that the owner was contacted when the I don't know what you call the thing, a thumb something or other, when it's vertical, the deadbolt is locked. That was locked when officers got there. There was no evidence of forced entry. You had officers on the perimeter when they got there. One of their functions is to check windows and doors and look for forced entry. They checked that on the interior. There's no evidence of forced entry. Tyler Dazey was the only living being in that house on the morning of January 18th. He told investigator Rosenthal that he owned a hatchet, which he last saw in his toolbox that morning. He also told investigator Rosenthal that he had just taken a shower that morning right before officers arrived. The hatchet was sent to the lab. Technicians could not state definitely if it had been cleansed or scrubbed. However, there was blood stains on the hatchet, on the head, the blade, and the handle. They didn't find.
I don't think that was concluded not in that way at least. They couldn't determine if it was animal or human blood. That was the question from the defense. And I don't remember that testimony being told that way from the DNA and blood expert.
I wasn't paying that close of attention. I'll have to take your
Actual
word.
blood, but they found the stains. So the question would be, how do you get stains?
Yeah, they didn't find the actual blood. They found stains that might have been blood. Have you heard that one before?
Yeah, I've heard that one before.
Yeah.
Well, it looks like blood. It must be.
Yeah. Oh, for frick's sake.
Is on there unless at some point there was in fact blood on there.
Oh, come on. Stop doing that. I have no issues with
The blood residue or the stains was swabbed, and they found that DNA of Jennifer Dazey on the handle of this
not
hatchet.
in the
There's marks on
blood
there.
sample,
The DNA lab person said
suspected blood
they're
sample.
marked and they're numbered. That's where they pulled the samples from. They're little circles marked with some kind of a marker. Obviously, the hatchet was scrubbed in the shower. There had to have been blood on there to get blood residue or blood stains, and there was enough on the handle to get DNA from it. Not enough on the blade, even though they tried.
And they never tested.
Further, the
what
handle of this
did
hatchet
he supposedly
had a
clean?
right palm print on it. And
No
they lifted
soap,
that palm print and
no
they checked
alcohol,
it with known
no
palm
bleach,
prints, and
no
that belonged
such
to
test.
Tyler Dazey. The lab tech couldn't say with certainty that the hatchet was scrubbed, but said the prints showed signs of either a wet hatchet or a wet hand when the print was left on the handle. Again, that was scrubbed in the shower. It came out, it was wet, the hand was wet. That's why we got the print on there, and that's why the tech saw that there was water involved when
just
that print
said
was put on.
That
the hand.
lab tech couldn't say. And now, but it was.
Echo the dog
That's
was taken up to the
weak.
veterinarian for examination. Dr. White determined the cause of death was sharp force trauma penetrating the skull. Maybe it was blunt force trauma, which was consistent with
Maybe
the
blood.
spike on the hatchet, on the back of this hatchet, the spike being driven through the skull and into the brain cavity of the dog.
But no blood or skull.
Dr.
or
Cruz,
brain
the medical
tissue
examiner,
on that.
performed an autopsy of Jennifer Dazey.
It's a lot
She
of
determined
maybe.
the cause of death was sharp force injuries to the head, face, and neck. There were 17 injuries, 13 of them to the face, head, and neck. There were 2 fingers amputated or nearly amputated. You saw those photographs. You saw, the autopsy photos. You'll have them again if you want to look at them further. They'll be with you. The fatal wounds penetrated Jennifer Dazey's skull and penetrated the brain, some 1 and 5 inches in depth on the forehead. The neck injury was 2 inches deep.
There should, if that was such an impact, there should be, you can't scrub away everything from a blade. There should have been, on the blade itself, there should have been some kind of skull fragments. That even the tiniest ones, but they should have been there. You can't scrub them all away. Unless you use bleach and really do a work with it. But they never tested for bleach or alcohol.
Went all the way to the vertebrae. There was damage to the vertebrae, but it didn't get to the actual spinal cord. The doctor also said these wounds are consistent with this hatchet striking Jennifer Dazey in the face and the head, given the width of the blade and
His
the wounds that
defense
she
is
observed.
not enough evidence, and
One
the
of Jennifer
doctor
Dazey's
had,
fingers was amputated completely and was found on a
opportunity and
nightstand. Another was hanging by a piece of skin. There was another cutting wound near the thumb on that hand. The amputated finger was either severed with great force and ended up landing on the nightstand, or it was placed there, but it ended up over on the nightstand. The severed fingers are also consistent with blows from this hatchet.
Ooh, Dave, would you do this?
Could the
Play-
defense record the stage closing and play it back for their closing, point out everywhere? I don't know if you could play an audio recording of it, but that's interesting. That's an interesting thought. But you could give it.
Because there's
could be
one
fun.
thing saying you heard the prosecutor say this, and here is how we rebut it. But if you actually play, pause, this is false. Play, pause, this is false. That would be interesting. Would you try that, Dave?
If I had the time to prepare it, because immediately after he's done, he sits down, the defense is going to go. But if it was lined up in a way where you had a break and you could actually get the video together,
Yeah.
you could. I don't know of a rule that you couldn't do it that way.
Interesting. Thank you, Not Sean Bird. I will be very interested to see if Dave ever has the opportunity, because sometimes it's before and after lunch. Or sometimes the prosecution goes all Friday and then it's defense on Monday.
Yeah. I mean, if you had the opportunity, definitely.
Yeah.
You could try
If
it.
you look at the blade on that, the narrowness of this
The
blade,
Young Thug hearing
and you
is
look at
on
a
the way.
hand,
I know, but
and see
I
how this
am
hatchet could
covering
have come
this,
down,
and then
taken
I will
those fingers
start
off,
with
and not
go over
affected
to
the small
that
finger and the index
screen.
finger. If it were a large wood cutting hatchet, probably would have got all four. But this particular hatchet, very consistent with those fingers and leaving the other two unscathed. It's clear from the evidence that this hatchet is the instrument of death for both Jennifer Dazey and Echo the dog. It's equally clear from the evidence that Tyler Dazey was the person wielding this hatchet. His palm print was on it. The DNA matches up, and he was the only one there, nobody else in or out of the house. He told Officer Rosenthal that he only slept about an hour the night before. He was in his room all night contemplating this attack. He took the hatchet from his toolbox. Naked, he went to the dining room where he removed the sheath and left it on the table. Then he proceeded to Jennifer's bedroom where he swung that hatchet 17 times, striking her in the face and head. She put up her hand at some point in defense. The hatchet came down, fingers came off. Given Mr. Dazey's statement, he's probably talking at the time this happened, calling her a whore or a witch before or during the attack. He left the bedroom. He was dripping blood in the hallway, in the dining room, blood spots when he came out and made his way to administer the fatal blow to the dog on the couch. Then he went to the bathroom, showered off, blood spatters. There was blood spatters on the wall, blood spatters on the jewelry box, blood all over everywhere. There had to have been a lot of blood over there with these 17 blows with this hatchet, including all over him.
Yeah, there were a combined 5 drops of blood in the hallway and the living room. That's it. That's the only evidence markers that was shown. 5 drops. Yeah, I don't like this, but a good defense attorney will point this out in their closing arguments.
So he went to the bathroom and cleaned up. While in the shower, he cleaned the hatchet, cleaned the blood off, but he didn't get enough because the residue remained, the staining remained, and that's how we got Jennifer's DNA off of the hatchet that was used to kill her.
It's such a stretch.
Left the palm print when he placed it on the shelf. He killed his mother with the hatchet. There can be little doubt of that. Now, let's take a look at your instructions. I'm not going to throw them up on the board and go through them. The judge has already read them. You're going to have them, but I do have to touch on some of them. The big one, is instruction 15 for murder in the first degree. Element number 1 is on or about January 18th, defendant struck Jennifer Dazey with a dangerous weapon. You have to go to the instruction number 20, which defines dangerous weapon, any device or instrument designed primarily for use in inflicting death or injury, or any instrument actually used or intended to inflict injury or death. This hatchet particularly is designed
I know.
as a killing instrument. It's got the big spike on the back. It's got SOG on it. In Army parlance, that's Special Operations Group. I'm sure the manufacturer is selling it to people as some kind of a battle hatchet. This is not a wood chopping hatchet. It's pretty obvious. It's got this big medieval looking spike on the back of it. But even if you believe that this is a wood chopping hatchet, then you have to look at it as an instrument used to inflict death. This is like a baseball bat. It's a baseball bat when used to play baseball. If you use it to bash into somebody's head, it becomes a dangerous weapon. So even if you think this is an innocent camping hatchet, it was used in such a way to make it a dangerous weapon. And it is, in fact, a dangerous weapon.
This is such a stretch.
Element number 2, Jennifer Dazey died as a result of being struck with the dangerous weapon. The medical examiner answered that. The cause of death was multiple sharp force injuries consistent with blows from this hatchet. Element 3,
Consistent with
that Mr. Dazey acted with malice aforethought. You have to go to instruction number 16 for a definition of malice and malice aforethought. So that says malice is a state of mind that leads one to intentionally do a wrongful act to injury of another out of actual hatred or with an evil or unlawful purpose. So actual hatred. Mr. Dazey stated to investigator Rosenthal that his mother was a witch who put evil on him. He said he doesn't need her to validate him and asked why would he care?
Sorry, what did you say?
I said, I don't like how he's reading.
No.
I mean, I know he's kind of going through a checklist, and that's okay, but I just don't like the reading part.
What a whore thinks. He said, you want to sit and drink yourself stupid, fuck like animals, and ruin your children's lives. Why would I care what a person like that thinks? He called his mother a whore often, said, you know how witches are. I'm better than you. I'm going to be your fear. I'm going to be your enemy.
There goes my
explains his mother's injuries when asked as witchcraft.
I mean, it doesn't sound half bad.
But there's also the
He also
evil
used
option,
the C word a lot.
alternative. And I'll just simply state that 17 blows with this hatchet to someone's face, head, and neck is evil. And if it's not evil, evil doesn't exist.
Oh, hyperbole more, please.
This was also a deliberated act.
Evil
not in a
based
heat
on
of
your
passion.
assumptions, sir.
You might be able to stretch it and say it was a heat of passion with one blow, but there were 17 of them. That's not the heat of passion.
Remember, Lizzie Borden was
The
acquitted.
time
folks.
Mr. Dazey decided to pick up that hatchet and unsheath it and then go to Jennifer's room was when he decided to do what he was going to do. There's no limit required. There was malice aforethought before each blow 17 times. He had fixed purpose and intent 17 times. He thought about this before he even took that hatchet out of the toolbox.
The victim
That's
had
premeditation.
a bunch of
That's intent. He
conviction
knew
for
exactly what he was
fraud,
going to do.
by the way.
Also, you look at instruction
This
number
is
19. In this one was used with malice, premeditation, and specific intent to kill. And malice aforethought is in another instruction, but the weapon itself allows you to make that inference. So the third element is satisfied. Element number 4 is the defendant acted willfully, deliberately, premeditatedly, and with specific intent to kill. We just covered some of that. Instruction 17 defines willful, deliberate, and premeditate. It's not accidental. 17 blows is not an accident. That's thinking about it 17 times. To deliberate is to weigh in one's mind, consider, contemplate, reflect. All occurred before he took that hatchet out of the toolbox, picked it up, took the sheath off, and went to do what he did. To premeditate is to think or ponder. Premeditation began at the beginning and followed all the way through after the murder of Jennifer Dazey to the killing of the dog. That shows premeditation because it didn't end with Jennifer Dazey's death. It continued on the whole plan to the dog. That's premeditation. It was the whole plan. Deliberation and premeditation need not exist for any length of time. You don't have to ponder this for days or weeks or months ahead of time. This can happen instantaneously before the act. As long as you ponder it and as long as you deliberate, that is premeditation. You go back to instruction 19, again, the inference. You may infer that the weapon was used with malice, premeditation, and specific intent to kill when a dangerous weapon was used and death results. make that inference. Make it. Now, you've seen all the evidence, all the crime scene, autopsy photos, findings of the medical examiner, the veterinarian, all the lab people came in. There was a lot of evidence you heard. You've heard from police officers regarding their investigation. You've been instructed by the court with the law as to what the law is. You need to apply those instructions to the evidence. Tyler Dazey took this hatchet, dangerous weapon, with malice aforethought, premeditation, and specific intent to kill. He willfully administered 17 blows to Jennifer Dazey's head, face, and neck, killing her with this. Use common sense, use observations, use your experience, think it through, and find Tyler Dazey guilty of first-degree murder and animal abuse.
Doggy!
That was nice and short and sweet.
Yeah. Opening statements was a combined 20 minutes. And closing doesn't seem to
Mr.
be-
Blair, whenever you're ready.
All right, let's see the defense. Let's see what they are going to do.
This is what I wanted to hear was the defense.
Come on. Stop doing this.
All right, you got to get down.
World of Doom. Yeah, I tested my broadband. I have 64 gigs of memory. There's nothing wrong on my end. This is the YouTube's thing.
Is it turned on? Test it. I don't know which number you have. He had one.
Yeah.
I have two turned on.
Look, I have excellent connection.
I'm telling you, it's me. Anytime I'm on your stream, it doesn't work.
Yeah, you're a disturbance in the fourth, Dave.
You're on.
I'm gonna set it. I'm gonna set it down here. Hopefully everybody can hear me. May it please the court,
Counsel.
counsel. Thank you. Could you actually, and I'll tell you, we'll want ours in a second,
I've got it on yours.
but we don't actually want it up there yet.
Yep.
Just gonna have this in front of me, I guess.
Thank you for being a member for 3 months. I can't remember. Thank you.
Okay. Starting off, first thing I need to say is thank you. Mr. Nelson already said it. I'll say it too. We talked about it a little bit during voir dire. You mentioned the fact that they wanted to serve on the jury because, among other things, it is their civic duty. I want to say thanks. The system doesn't work without it. I believe in the system. I have to believe in the system. We talked a little bit about what's different in our system. And I think that
Oh,
our system.
no. And he shows the mosquito that was
You.
faulty.
And so I say thank you.
Get your act together, Ellen Seward.
Gonna do.
No, this is the
Mr.
court. This was the same during the prosecution's opening statement.
I'm not
Horrible.
going to walk through the case step by step. Read to you from the jury instructions. I will talk briefly, very briefly, about one jury instruction. And I'm going to try to keep this relatively short and to the point. I only get to talk to you once. Mr. Nelson gets to talk to you twice. And after me. And he has the burden of proof. And we talked during voir dire a little bit about that burden, what that means, what that burden of proof is. All right. And you've got the instructions and you saw them. You can read about how it works. Somebody, I forget who it was, right away when question during voir dire, piped up right away and said, when I asked, what does the defense have to prove? He said, nothing.
Dave, you're used to calling the court.
Clearer now than it ever has.
Yeah, you want me to give them a call? Tell them to fix their mics.
I say that because of one particular instruction. Look at jury instruction number 10, talks about the burden of proof and guilty beyond reasonable doubt. Only place this occurs in the jury instructions. And this is by design. In the second paragraph of that instruction, it says, a reasonable doubt is one that fairly and naturally arises from the evidence in the case, or from the lack or failure of evidence produced by the state. And yeah, I put emphasis on that. And then down in the last paragraph, it says, if after a full and fair consideration of all the evidence in the case, or from the lack or failure of evidence produced by the state. It's the only jury where they do that. Themselves. Because that's the crux. They're trying to make sure you understand who has burden of proof and what. It isn't just about having presented some evidence that evidence probably happened. Okay? It's a did they plug all the holes? Give you the puzzle. Give you half of the puzzle pieces. Remember, as you look at the evidence, and you're going to have the chance to take all of this stuff back with you, all right? It's not the crime or how terrible the crime is. We all state those pictures that they show them to you. Real instance of crime, not facts of the case. They want you to get your emotions and not what it's really about whether or not the state has proven beyond a reasonable doubt the defendant is the one who killed Jennifer Dazey. That's what the case is. Remember Mr. Hoover's opening statement? I'm going to talk. We're done. You're going to understand what we're.
This is frustratingly horrible.
Yeah.
Everybody does this. I understand that.
Now, from what I hear, he's doing good.
Sometimes
Problem is, can't hear it.
I know. It cuts in and out.
Take the path of least resistance. Sometimes they take the easy way out.
It seems like one of the microphones used in this courtroom is just flawed. And because the state's opening statement a few days ago, same thing. Cut in and out all the time.
Sometimes, you've heard the phrase, round up the usual. And it hasn't just survived from the movie. One of the ways in which take the easy way out. They take the path of least resistance. It's how it's done, unfortunately. I'm going to talk about certain items of evidence. You can see this pattern. You can see how this happens. For example, the first items of evidence we see in the case, we heard from Christy Folman and we heard from Officer Hasselbecker. Okay. We also saw the ring cam video and Officer Hasselbecker's body camera video. And when I forget if he had one on when he came in here, but we got to see the body camera footage. And in all of that footage, one of the first things we see is Nick Frey's truck sitting in the driveway. All right. And Christy Folman and Officer Hasselbecker both told us about that they saw that as well. Christy Folman told me that the GMC is not at the house. All right. Now, we know from Investigator Hoff's testimony that Jennifer Dazey was in Acadia and filled up the gas tank in the GMC station because he went. With the interview with Nick Frey from the officers, Nick drops off the Acadia. evening of the 17th. All right. Of the officers reporting what they heard, I think it was Investigator Crable, reporting what he heard from Nick Frey, was that Mr. Frey had then driven, at some point, drives out of Dubuque towards Cedar Rapids. A big deal of the fact that they followed him on the cameras as he drove out of Dubuque towards Cedar Rapids. But you notice they didn't ever confirm where he went in Cedar Rapids or that he ever arrived. They didn't continue to watch the cameras when he came back. Whether or not he immediately turned around and drove back. It that long. Interesting things about that whole scenario. To see a couple of clips of the ring camera footage. We were told that Nick stopped at the house and that there was ring camera footage from the front door of Nick exchanging vehicles.
This
Did
is
we?
frustrating.
We were told about it.
Oh yeah, the jury can hear him. This
Does that seem like
is
something
just
that we
for,
should have seen?
his microphone is just for the audience.
After he drove to Cedar Rapids, or in the direction of Cedar Rapids, go the places that he said that he was going to go, things that he said he was going to do? Or did he turn around and come right back? That seems like it's very similar. In their closing argument, the state just said,
Oh, this is frustrating. I think he's doing really good here, but we can't hear it.
We're assuming, like the prosecutor.
Yeah.
I'm going to take a cue from the prosecutor
Tyler
and
Dazey is left there
assume
right-handed.
a lot of things, and I'm going to assume the closing is really good.
But we don't have that evidence, do we? It's not in evidence. It's not there.
Oh, this is frustrating. Super frustrating, because this is what I wanted to hear.
Officers talked to lots of people, including his brother and sister, according to Investigator Crable, who would know the answer to that question.
This is so frustrating.
The picture? Yeah. Yep.
The picture.
This is another item of evidence that's of significance. We talked a lot about the back door. All right. Christy Pullman.
Jody,
This
did
is-
too.
That back door
This is not
was
the
pretty much
Yogi Aris
never used.
file.
All right. But if you look, and Chad Stair, I'm sorry, I may have his first name wrong. In any event, Corporal Stair told us that those steps have clearly been walked on. And two investigators told us that it had just snowed quite a bit with several days. You can see the ring camera there in that picture, up in the corner of the door. You saw other closer pictures. I'm not going to page around and show you that.
And Nick, you should just
What I
mute him,
would
read
note to
his
you is a couple
lips,
of-
and give the closing for us.
The door is locked. But that didn't lock the door when they left out the door. All that requires is a key. Now, that leads to some interesting. The last knew, and this would have been at the time Kylie moved out, but the only keys were in the possession of Kylie and Jennifer. And then we heard from Investigator Hoff when he's investigating at the time of the incident that there is a dispute because Kylie has never returned the backdoor key. Did anyone ask Kylie about the backdoor key? Did anybody get the backdoor key from her? Does that seem like something that we know? And if you think about it, I believe it was Investigator Hoff testified that at some point later in the case, he actually gets a key. Did you receive investigator? I forget what the question.
Oh, this is so frustrating.
It's
Because-
made me want to quit my job and go home.
Yeah. I am home, so I can't quit and go home. I'm already there.
Investigators talked about, and they showed us, there's actually a close-up picture in the evidence, and you can look at it, of that camera. It's a, right? Same brand, same, not the same type of camera, but the same system as the one on the front door.
I know what the
Investigators
issue
told you
is.
that they were able to get footage of the one on the front, but that they could not get
I
any
know exactly what the
from the
issue
one on
is.
the back door.
He has a wireless transmitter
Now, the
that's on the
subpoena
other
that
side
they
of the body.
January 1st, January 19th, which not only would have covered the date of the incident,
See the lapel mic?
but it also would have covered the time that the officers were out there taking this
Yeah.
footage.
He has a
For some-
lapel mic, and the transmitter is like
Investigator
on the
Hoff tried
opposite
to tell
side of
you.
his body than the
He got up to
receiver.
direct examination, and he tried 3 ways that could happen. Either the camera was taken, somebody hadn't paid for that camera's footage to be saved, or nobody went, that there was nothing, since it's motion activated, there was nothing that triggered the motion sensor. On cross-examination, you will remember the judge was nice and allowed me to ask, I think, the first 4 questions of cross-examination. We kind of one attorney, one witness kind of thing. You probably noticed that as we went through it, but that was the one exception. I was allowed to ask 4 questions, and then Mr. Hoover took over the rest of the cross-examination. And what I asked him about was the Ring camera app. And he acknowledged that what he didn't tell you on direct examination was you can go into the Ring, you have access, change. And he couldn't tell you who had access to those Ring cameras.
I never checked in on who had access.
Isn't that something that we should know? He talked about, one of the examples I used was, I used one from my own life and I asked him about it, but you know, could I have the Ring camera app on my phone and my wife would have it and my daughter would have it? Which is in fact the situation. And he said, yes, if I share it with them, they would all have it. It would require me to share it with them, but then they would also have access to that app and any of us could turn off that camera. Interestingly, because it's about finding her phone. All right. Did anyone even check Jennifer's Ring app on her phone to determine whether or not it indicated that the camera had been turned off? Whether it was functioning, whether it was recording. Did anybody even check?
Nope.
Be nice to know that, wouldn't it?
Yep.
Another example in the evidence was the DNA print. Remember about my neighbor who wanted to sniff and feel my grass?
What?
One of the pieces of evidence that
Yeah.
we talked about at
How
that time
how
was
DNA can get
my neighbor's
done.
ID that was
I feel like that's innuendo.
question was whether or not What was the significance? Kinda. I asked, does it make a difference? If fingerprints are on the ID.
Thank you. Thank you, Q, for your
Does it
super
make-
sticker.
If my neighbors,
It's not how close the microphone is, it's jumping in and out. Jesus Christ.
see,
Yeah,
You've
because
correctly
I get
pointed
the
out.
same thing
well, no, it's the neighbor's ID. You'd expect to
With,
find their DNA and their
Bluetooth.
fingerprints on it, right?
if there's a barrier, sometimes it'll interfere.
In that little,
Yeah.
you got to see, and you figured out the limitations of DNA and fingerprint evidence. All excited about DNA and all sorts of scientific, most of which is either completely fictional, yeah, in actual application.
Oh, this is so frustrating. Oh, wow.
It didn't work. It is working.
It's so bad.
What
This should have been
we-
tried
our case,
out
we got to see the
long
limitations
before.
on that type of
Does
evidence.
this microphone
great
actually
detail.
work?
We also got to see the way in which the necessary and fill those gaps. Minute. Do you remember item 7, first, the DNA report? That was the blood drop on the floor in the living room, the one that was down near the couch. 4 in the picture. You can go back and look at those pictures. But what was interesting about it, during off, told us that it was sent.
Thank you, Q. Yes, don't forget to subscribe to me
Experts, and they
because I
got the report
stream
back, and that
once
was
a month.
Jennifer Dazey's blood. Remember that? And then, when
Ooh, we got Jody
there.
tomorrow.
on direct examination,
Nick and I, Jody.
Yay!
mistake. I don't think she meant to say it, right? But she, my memory at least is, and maybe you caught it, she actually went so far as to say, in referring to item number 7, that was Jennifer Dazey's blood. And so you probably noticed on cross-examination, I got a little ridiculous with her. I went go way out there. He couldn't say DNA. They didn't test for that. Is there?
Yeah, they didn't test the blood if it was animal blood or human blood.
Determine whether it was
determine
human or
if the DNA was either touch DNA
They didn't test for
or
that.
from the blood itself, because they didn't test if it was human or
And it might have
animal
seemed a
blood.
little silly at the time. But remember they swabbed Tyler Dazey's nose and it tested positive. But I made her say he couldn't tell you that the DNA, that Tyler Dazey's DNA, blood, or that was Tyler Dazey's blood. She couldn't even say that was Tyler Dazey's blood. Why is that important? They didn't test for any of the blood, any of the DNA. They didn't test for it. Does that seem like something we ought to know? We went through every item of evidence with the DNA expert. We talked about each of those items.
I
Whether
can
or not the
explain
DNA comes
Donna's
from the blood.
question. I can answer
You
Donna's
developed a
question.
DNA profile. Did it come from the blood or did it come from other sources of DNA? No, not.
So so we're talking about the general rule of hearsay. So police reports are hearsay, meaning that they're out of court statements, and if you're trying to introduce them, you're offering them as proof of the truth of the matter asserted. There is an exception for regularly conducted business records, but it's been held that police reports are not regularly conducted business records, and so therefore they don't fall into any hearsay exception. So you can't admit them into evidence. You can use them to impeach or to refresh memory, but you can't introduce them into evidence because of the hearsay rule. And the same thing applies with the police interviews, interrogation videos. If you're the defendant, you can't introduce that because it's hearsay. It's an out-of-court statement offered for the truth of the matter asserted. If you're the state, you can introduce them if you want, because one of the exceptions of the hearsay rule is a statement by a party opponent, the party opponent being the defendant. So you can introduce them to get the defendant's statements in. But if the defendant says something good, you can't introduce it as a defendant because it's hearsay. This is why you never talk to the police, because best case scenario, they don't introduce it and it's no harm, no foul.
Yeah.
But you can never use it as a affirmative or an offensive tool because it's excluded by the hearsay. So you don't ever talk to the police ever, because worst case scenario, you say something that they're going to use against you. Best case scenario, nobody can use it. So there you go.
The defense attorney tried to use the rule of completeness because the last witness for the state testified about statements the defendant made to him. And the defense wanted to have the interview played through the jury as a rule of completeness. The judge didn't allow it in because
they generally won't.
The entirety, you can enter it into evidence, the part you want in, but you can't just play all of it just because the cop.
It violates a lot of hearsay rules if you let all of it in. And it goes for body cams. It goes for anything. If the defendant is making a statement on a video and the defendant wants to introduce it, you can't because it's hearsay. The defendant could take the stand and say things, but you can't admit video. If you're doing it against a party opponent, you can. And that's one of the other things. I don't have a problem with that rule if the courts would say, the investigating officer is the state, so is a party opponent, then you could introduce it. But the courts have continuously said there is no party opponent on the state's end because there's no party. The state is a fictional entity. There is no individual. So you can't admit hearsay. That's the other thing too. So say the cop got on the stand and said, oh, I said X, Y, and Z. When you have a recording that he said A, B, and C, you run into a bunch of hearsay issues. Again, you can use it to impeach him, but you can't use it affirmatively or offensively. Okay. So there's a lot of issues with that.
Can you tell me one exception? You tell me whether or not the blood came from a human or an animal. Could have performed that testing. You tell me whether.
Yeah, recordings are entered into evidence in the Youngstown trial all the time because
no.
Well,
because impeachment,
all of that is
effect on listener was one of them. Yeah,
didn't do that testing. Wanting. Didn't do that testing. Don't know that answer. And it really made for some interesting, if you look at the DNA evidence, it really made for some interesting because it gave you their theory of the case. And they put Tyler Dazey in the shower washing off Jennifer Dazey's blood in their version. Did you get that? And they swabbed the tongue in the shower. Really quite interesting was the one they did.
This is a good argument. I know
positive. The tub drain tested positive for blood. Don't know if it's human or animal. Did not find Jennifer Dazey's DNA.
They did not find Jennifer Dazey's DNA
but supposedly,
in the shower or around the shower drain. But they didn't test in the shower drain because they couldn't get it off.
DNA expert told me that blood is an excellent source of DNA. And it's not there. Oddly, the blade doesn't test positive for any blood. There's no DNA found on the blade of that hatchet.
Didn't test positive. The
And
claim from the prosecution is
apparently,
it was
there
residue.
was no testing done to determine if the hatchet had been cleaned.
Oh, this is a good, really good part of his argument, and we can't hear it.
We also have a fingerprint expert. That was some testimony. State called a fingerprint expert to tell you palm print, hatchet, belonged to Tyler Dazey. Remember the driver's license that belonged to my neighbor? I don't know that it's terribly significant that Tyler Dazey's palm print is on a hatchet belonging to Tyler Dazey. It's significant that also on that hatchet at some point is Jennifer Dazey's DNA. I don't know. Know if Jennifer uses that hatchet. Certainly an object that's in her house where she's been living. But our DNA expert told us that it would not be unusual for somebody's DNA to be on objects or in they use or frequent. It's called touch DNA. You leave DNA when you touch things. It's your cells. It's the oil in your hand. It's all that fun stuff.
Yeah, the lack of sound is because they gave him a bad microphone.
Breath when I exhale. Which was true. The expert did talk about signs of moisture in the print, but she admitted that that could be due to any number of possible causes, including sweat. One other thing she talked about really hasn't talked to you about, and they may attempt to now, but I'm sure they'd like to stay away from it, is the smudges in that palm print. Because the state's fingerprint expert admitted on cross-examination that caused by some
Yeah, something was
using
overlapping
that hatchet
his palm print.
after the print had been left. Basically, you leave a print on something and then somebody else touches that. And the spot where they touch it is then smudged or could be smudged. I believe one of the things she said was, especially if that person was wearing gloves. Investigator Rosenthal told us about the arrest of Tyler at the hospital and the subsequent attempt to interview him. You remember all that? He talked about Tyler's odd behavior. It was actually odd enough that instead of taking him to the law enforcement center for an interview, they actually
They took him to hospital first for a mental assessment.
all-time.
This is so bad. Wish we
we
could hear it all.
Regarding speak louder than words. What is the fact that they took him to the hospital first? What is that saying to you? Did you catch the part where one or more staff up at the hospital in the behavioral health unit of the emergency room, as they were talking about it, was familiar with Tyler? That came out in Investigator Rosenthal's testimony on direct examination. The state elicited that. It was right there. Investigators talked about some of the things that happened up at the hospital and tried to imply that Tyler was just being difficult or obstructionist.
Oh, I'm quite sure this is a really good closing argument. And we can't hear it.
Investigator Rosenthal also told you about his attempt law enforcement center. Remember that? He told you about some of the things And on cross-examination, we talked about a few more of the things that were said. But making a lot of sense.
Dave, do you have to do
Yeah, I have to go do work stuff. I got to finish up this motion. I need to like focus.
Yeah,
but
you need your billable hours.
I
You
do.
lawyer.
Yeah, I know, right? What time's your stream tonight?
6 p.m.
Okay. All
Yep.
right. Cool. Send me a link. I'll be there.
Yep. Okay. See
All right.
you later.
Oh, wait. Oh my God. The sister put out a TikTok video about this case.
Oh, really? Find me the link.
Send me an email with the link. Hit us up somewhere. We need that. I'm putting my email in the chat under Nick's name because that's how it works. But send it to me. I'll get it to Nick. We need to see that.
Yeah, we need to see that.
That's going to be amazing. All right. Take care, all.
Yep. See you later. And we will continue to try to listen to this. This is so infuriating.
Investigator Rosenthal tried to make a big deal about Tyler's alleged last conversation with his mother. But as we brought out on cross-examination, Tyler didn't answer him.
Oh.
Was he talking real person conversation? Or was he talking about a conversation that they were supposedly telepathic as they exercise entanglement and no. He actually talked at that point about his mother practicing witchcraft upon him. So was Tyler actually talking at a or was he talking entanglement or whatever? Investigator Rosenthal also talked about Tyler.
This is so infuriating. This is good stuff.
Thing and the floor and pick it up before they got Tyler out of the car. And he said he went back, he watched that video, a video we never got to watch, by the way. Wouldn't that have been nice?
John, I'm going to check. Talking about things that are not enough.
That's true. Keep your comments to what the evidence was.
Approach?
Yes.
Yeah, I mean, they should be allowed to talk about things that the state chose not to enter as evidence somehow. Because if it was referenced by testimony, skipping ahead, hopefully they will change his microphone. Change his microphone, please. Change his microphone. No.
Thing about that told us about is that he told us about a conversation that was happening between Tyler and his dead mother who was there. Really a mental conversation? Was the conversation that took place in the back of the squad car when Tyler was the only one in the squad car. Investigator Rosenthal also tried to emphasize Tyler telling him Tyler had seen the hatchet that morning. But according to Investigator Rosenthal's testimony, Tyler didn't tell him where he saw the hatchet, only seen the hatchet. Investigator picture that the state just of the hatchet, found it on the shelf above the toilet. And Tyler told Investigator Rosenthal that he had showered the night before And sometime that morning, did he see the hatchet at some point in the bathroom? We don't know. I'm not going to talk about everything that was said during the attempted interview of Tyler Dazey. I'm simply going to remind you that Investigator Rosenthal told you that the whole interview was recorded. And I'll leave it at that. Do you remember Investigator Rosenthal's? He told you about how he tracked her on the traffic cameras around her Life 360 app. Remember that? Remember we talked early on in opening, we talked again, a little bit of least resistance, about taking the easy way out. He after she dropped off at, I think, 10:30 until the next morning when she goes back to work, she comes out of her house and she gets a cab. In any event,
This was also a good part, and we can't hear it. It's
all
so
night.
infuriating.
It was impressive. Get to the part where, from the camera he was watching, as he did, he couldn't see any of the entrances or exits to that residence. And he told you that there were thousands of cameras downtown. Right, actually, that there were over 1,000 cameras in the was his exact testimony. In the day. And they did no testimony that he did any her residence at any time overnight.
They didn't even check if there were other cameras in the area where they could see her entrance or exit.
As he admitted on cross-examination.
Oh, this is infuriating. And I can't do anything about it. Yes, I know. I will go over to the YSL stream as soon as they are done here with the
as they told
closing
us,
arguments.
There are no cameras on Avoca. Investigator Crable's testimony, he talked about the interview with Kylie, and you got to watch a portion of that interview. And he told you, everyone deals with grief differently. But did her demeanor and attitude, the giggling and laughing, did that strike you as odd? Now the investigator in this section would suggest to you that this is a perfect example of what we're talking about, of taking the easy way, the path of least resistance. Because if Tyler wasn't, I wouldn't be the one talking to you about that video. They would be. Because Kylie is the next path of least resistance. She's the next usual suspect. And
yeah, she admitted in the cop car that she had
usual suspect.
She was fighting a domestic case against her mother, where the mother said the daughter slapped her.
I can't prove that Kylie killed Jennifer Dazey beyond a reasonable doubt based upon the limited evidence that we have here. My point is that the state really hasn't ruled it out as a possibility. They basically pretended to do it.
This is a good argument.
That for your benefit, but they didn't actually do that. It was just a show. The same can be said for Nick. I can't prove Frey killed Jennifer Dazey under reasonable doubt, not based upon the evidence that we have, not based upon the evidence that's been presented by the state in this case. Likewise, it proved that Tyler Dazey killed Jennifer Dazey, not based upon the evidence presented in this case, not based upon what's come in during this trial.
It's infuriating, and I can't. That he is being given a faulty microphone, and I can't do anything about it. Okay, he is done. Or
Just did a murder. Presented. During that, you heard about lots of things that could weren't, but weren't. Usual suspects. Supported the conclusions, and then they that conclusion was the first 5 minutes of the investigation when they entered his bedroom, possibly even before that. They avoided questions, even some and actually support those conclusions. This isn't a. This is 4 pieces puzzle, and they want you to say not only that it's a cow, kind of cow, and what. Still missing 5 or 6 pieces with all the crucial information. Ladies and gentlemen, any of these alleged crimes. Please look at the evidence. Pay particular attention to what is missing. And then return a verdict of not guilty.
Mr. Nelson, whenever you're ready.
okay, now we can hear the prosecution's rebuttal.
First of all, there's an instruction that you need to look in there in that packet that says what we as attorneys say is not evidence. I gave you a whole lot of evidence. When I was up here talking, Mr. Blair gave you a big old mud ball against the wall. He's hoping something sticks. This was basically obfuscation. That's throw a whole bunch of static into this and try to picture something that it's not. He complains that it's everybody else's fault except Tyler Dazey's. First of all, inadequate police investigation. You all sat here, you heard from the investigators. There was an extensive investigation done on this case, and everything points to Tyler Dazey. Now, the next claim is somebody else did it. Oh, it was Nick or Kylie. Well, why aren't there palm prints on this hatchet? Pretty clear, this is the instrument that caused the death. Tyler's palm print is on the handle of that instrument. We heard evidence from experts, not from attorneys, experts that said how those palm prints can be on there, that there was water involved, either on the hand or on the handle. That's not Nick's or Kylie's handprint on there. The ring camera was another thing Who controlled that? Well, there was no code found for the phone. Nobody can look into Jennifer's phone to find out what was going on with that. It doesn't exist. It wasn't evidence. Again.
The objection's noted. Go ahead, counsel.
You have to remember, use your notes, use your own memory as to what was or was not in evidence. That's something that was not available according to my memory. Ring was contacted. They got evidence from them that said that there was no activity on that particular camera. There's all kinds of reasons why that would be. Maybe it wasn't paid for. Ring did not give that up. You have to pay an extra, what, $50 a month, I think was what was
But
talked
you
about.
didn't
There's a lot of people
check
have
it.
those cameras, decide it's not worth paying that kind of money, take it off. The lab tech, DNA, a lot of hay was made about, well, she doesn't test for blood. She tests for DNA. On occasion, she's going to test for blood. But in this particular case, she's swabbing. There was blood found on another test. She swabbed the stain. And on one of those stains on the handle, she was able to pull the DNA out of there. Okay, she doesn't go test for whether it's animal blood or whether it's people blood.
Why not?
And during the course of that exchange, I asked the question, would you expect to find Jennifer Dazey's DNA in a drop of animal blood? Obviously not. We don't have to be experts to understand that. Experts talk in a whole different language than we do. When they say, I can't conclusively say that, what they can say is, well, I'm 99.9% sure, but I can't be absolutely conclusive. That's how they talk. Well, we can turn around and say here that, well, she can't be absolutely certain. Well, you see the difference. What the lab tech said was the DNA was found on the hatchet and it was swabbed from a blood stain. How could there be a blood stain on the hatchet if there had not been blood on the hatchet? Now, to talk about where it went, well, we're speculating more of the mud ball, hoping something sticks.
But they didn't test if it was blood at all on the hatchet.
I think
They
we talked
assumed
earlier
It
about
was blood.
the video stuff.
And they found
And I asked you
DNA.
early on, I said, some people are of the opinion in this day and age that if it's not on video, it didn't happen. Mr. Blair is pushing real hard for that. He wants you to believe that, well, if it wasn't on video, it didn't happen. This is a case where you're not going to have all kinds of video evidence. It's not available. This is old school. We have to go by all the evidence. You have to use common sense when you go through it. It's circumstantial evidence, and it all leads back to Tyler Dazey. Now, one of the big defenses in this case is Kylie did it. Well, Kylie lives across town. In order for her to do this, she'd have to slip away from her house. I mean, Investigator Rosenthal spent days going through traffic cameras, tracking her movements around town.
one
in order
camera.
to eliminate her as a
No,
suspect.
no. That's
Days he
false.
spent digging through this stuff. In order for her to
That's simply false, prosecutor.
participate
was
in this,
not
to be part of
in
this, she would have
testimony.
had to leave her house at the other end of town somewhere during the course of the night, through the back door, get out of a nice warm bed and get out into that cold air and then sneak around through the alleys and through yards and then get a hold of an
But you
Uber or
never
a cab
checked.
because she didn't have a driver's license and she didn't have a car. How was she going to get across town? Okay, she'd have to
You-
go through all that, get
They never checked with Uber to see if somebody drove to that address. They never checked.
over to Avoca Street. She couldn't get dropped off right out front, so she'd have to be dropped off blocks away perhaps, and then work her way over there. There were no tracks in the backyard, human tracks. She would have had to go up the driveway where she could have been seen, and then she would have had to enter the back door with a key that she may or may not have had. And then she would have had to go in, get a hold of
And
her
you
mom's
never
phone or some phone, disable the camera, erase all the footage that was on that camera,
Did you
and
check?
then go in there and sneak in to Tyler's bedroom, get the axe, the hatchet, out of his toolbox without waking him. And remember, Tyler said that he only slept about an hour the night before, an hour. So she would have to time that to get in there when he was sleeping during that 1 hour and get the hatchet out of the toolbox and take it out. She would have had to strip herself naked because there was going to be a lot of blood and go in and commit this act and also kill
Why?
the dog and then go in and clean herself up, put the shower or put the hatchet up there in the shower,
Why?
go get dressed. Then she'd have to sneak back into Tyler's room, lift up his right hand and get his palm print on the hatchet so she could put it back
This is
in the
so
bathroom
stupid.
where it was found. Now,
You never
Tyler also said
all of this
he
is
last
so
saw the
stupid.
hatchet that morning before police arrived. How could he see it that morning in his toolbox when it was
Yes,
actually over in the
I
bathroom?
will send you all over
You
to
know,
the
it was a
Youngstown
nice try.
hearing
Let's
what
throw this
is
whole
done.
story together, but it
I'm
doesn't
streaming
fit.
that
What we got here is a whole lot of evidence that got presented, a lot of evidence. It all goes right to Tyler Dazey, all of it. We're not here to eliminate everybody in the state or everybody in the country. That's not the function of law enforcement or my office. We're here to gather the evidence, and we're here to prove that Tyler Dazey committed this crime. We have done that. We have presented all kinds of evidence, scientific evidence, investigative evidence, physical evidence. It's pretty clear what happened here. Circumstantial evidence. Tyler Dazey was the only living being in that house. The only one there, nobody else. Nobody came in the back door. Nobody was sneaking around through the night. It's just not there.
Never
Look at this
checked.
evidence for what it is. Circumstantial evidence. It takes us right to where we have to be. Mr. Blair says this is not about milk cows. It is, folks. All the evidence is there. There might be one or two little pieces missing, but when you look at it, that milk cow is right there, plain to see for everybody. Tyler Dazey committed this act. It was a heinous act. There's no other way that anybody else could have done it. It was him. The evidence points to him. It confirms it. Find him guilty of murder in the first degree and animal abuse. Thank you.
All right. Let's see if I can put this is her. This is, yeah. So let's listen to Kylie Dazey. No.
I have a story time. I was arrested. Obviously, we need context, but it starts with me living with my mom. I was living with her. I was paying bills. We were fine, other than her starting physical fights, which is another story. The night before I moved, after searching for an apartment for so long, she looked at me and said, "You know, me and your brother were talking and we thought it'd be funny. It only takes 2 signatures to put you in." Me not liking hearing that, I ask, "Why would you say that? That's not funny." She goes, "Well, you're the only one in the family now in the system." Right there, shows a little crazy. I end up moving on a Friday. I go back to my house, my old house, my mom's house, Monday. I have a story time. I was
And
not even 20 minutes later being arrested. She called the cops saying I'm trespassing, I will not leave, and I slapped her foot. I have my rights read to me. I'm in jail for about 14 hours listening to a girl scream the whole night. I have court in the morning and I had to go to work. There was a no contact order set in place, so I could not go get my car. Luckily, my father
you had
and
a
his
car.
girlfriend helped me. In the meantime of them getting my car, I was trying to find someone to cover my shift at work because my boss said, "Figure it out." I would have made it better if this was tea. The no contact order did last a few weeks and then got lifted. I am still fighting this case right now. I do have a simple domestic on my record for my mom saying that I slapped her foot. To about
Okay. Slapped her foot. Well, Yeah, and she says she has a car, and nobody looked into it. She had a car. The prosecution said she has no driver's license. She has no car. She says here she had a car. All right. Oops. Now, finally, almost an hour late. No, an hour and a half late. My deepest apologies. I can send you over to the Young Thug Rico trial hearing. Let me just set that up, start it, and play a song as intro. And then I will send you all over there. Now, regarding this trial, I am not close to beyond a reasonable doubt. Not even close. The prosecution's closing actually drove me further from it, from their absolute shameless speculation. Absolute shameless speculation about how this event happened, because they didn't prove much of it, in my opinion. But, okay, I will send you over to the Young Thug thing. And yeah, I will see you over there. And hug your family. And unless your family is trapped, then screw them and give your love to the people who deserve it. Okay? Bye-bye.